Chino versus New York City Department Financial Commission. Services.
Good afternoon. Can you hear me okay?
Yes.
Okay. May it please the court, Pierre Sirik, representing appellants Theo Chino and Chino Limited. We're asking this court to reverse the lower court's holding because appellants
So,
have...
counsel, did your client submit a complete application, or did he leave portions unanswered?
So, in terms of which is essentially, you're asking essentially around the exhaustion argument.
Did he exhaust his remedies?
Whether he
Yes.
was in fact supposed to exhaust all of these administrative remedies. Our position...
Could you just speak up a little, please?
Right, okay, all right. So our position is that the exhaustion doctrine does not apply in this case if actually appellants wanted to directly challenge the regulation within the statute of limitations after promulgation. He was authorized to do this without having to complete. What he went through basically is he started immediately following promulgation to actually apply, discovered through the process that the burdens were significant. He filed an Article 78 in October 2015 within the 4 months time frame after he received a letter from the Department of Financial Services essentially asking for more information. He essentially...
They weren't asking really for more information. They were stating that the application was incomplete and what sparse information or sparse information, I'll use that term, on the application, they couldn't process the application. So in actuality, they were asking him to just, answer the questions on the applications and they would act upon it.
And pay the fee.
And pay the fee, which goes back to the burden, but yes.
So how was he under these circumstances injured?
I'm sorry, say again.
How was your client injured under these circumstances?
Okay, so in terms of the, if I could just address the exhaustion real quick, under the Watergate...
Exception.
Yes, there is a bunch of exceptions under Watergate 2.
And your exception, you're claiming
In fact,
it's
we're
unconstitutional.
claiming all four, the excess of statutory power by the agencies, the big one, the lack of constitutionality of the regulation is also something we claim. The futility and the irreparable harm are also there, but we just need to
even
win on
under the
one.
exceptions, you have to have an actual injury.
Yes, absolutely.
Right, because here's the thing, because your client did not finish the application process, quite frankly, you didn't get a determination from DFS. All they said was, we don't have enough information to figure it one way or the other, right?
I totally concede that,
Okay.
yes.
So now, isn't it, so, okay, I'm going to go back to my colleague's question. So what's the actual injury?
Okay, so if we look at the injury in fact issue, which is this whole, the central question of whether a startup business, when they are essentially on the launch pad and are actually going through...
Some of the things that you were claiming as injury, in fact, for example, were the loss of the contracts with the 7 bodegas and the development of a custom operating system that then you lost, and the purchase of equipment. Are those the things that you're claiming are injuries, in fact?
Yes. So you have to realize in terms of the timeline what's going on. He starts to launch the business. At the same time, New York DFS is interested and gets through the whole review process of the regulation. He goes through a 3-year process between 2013 and 2015 to figure out, to establish the business relationships with the convenience stores.
But how did this regulation, you're saying that the regulation itself caused him this injury. How did the regulation cause him this injury when he never even completed the application to get an answer from the regulatory body?
So similarly to, if I may make this analogy, I lose my driver license, I'm not going to get on the road. If I lose my law license, I'm not going to practice law. I know that I'm not going to get this license awarded by New York DFS. I actually challenged it first in October before he gets his letter in January.
You're not going to get it. I mean, that's really the thing that is baffling me.
If you lose your law license because you don't pay the fee, if you pay the fee, you're going to get your law license. If your driver's license, if you don't properly fill out the application or you don't take the photo, you're not going to get the driver's license. But if you go back and you pay the fee and you actually fill out the application and get the photo, you're going to get the license.
Absolutely, Your Honor. The big difference here is that he had to have a shot at filing a claim, an Article 78, built on two major arguments, which is, number one, the fact that there was an excessive statutory power, and number two, that the fact that the regulation was...
Can I ask a question? Is a possible outcome of applying for the license, and in fact, he said in ways this regulation doesn't even apply to me. So if you got a disposition that said, gee, you're not even covered by this, no worries, don't pay the $5,000, or there's something short of a full license that you can get if you're a small business. So then, how can you anticipate an injury in fact that if you do an application, you're not going to get a license, or you're going to have to come within it, or the license that you get, that it wouldn't be appropriate?
So the injury in fact analysis, the appellants must have a shot at challenging the regulation on the basis not of the license necessarily, but of the record before the court, which is essentially the pleadings, and he must be recognized an opportunity to challenge the regulation on that basis, not on whether or not there was more or less information on the application.
So under your scenario, though, if somebody doesn't make an application at all, they just don't put in an application, they don't get a determination, are they allowed to come in and challenge the regulation on constitutional grounds?
The Watergate exceptions are applying here, which means that in terms of excess of statutory power or constitutionality, he had the clock running against him.
But suppose all those arguments are viable, and I'm not conceding that they are. You still have to have standing.
Yes.
Right.
Yes. So
it's not the same as exhausting.
Absolutely, Your Honor. Absolutely. Exhaustion is one thing.
It's a different concept.
If I may just address
Yes.
the injury in fact question. In terms of the injury in fact, based on the pleadings, he fell under the regulation based on Section Q2 and Section Q4 because he was providing exchange services for the convenience stores. There was no way out for him to fall out of the regulation the moment he was exchanging the Bitcoin
But he wasn't
or
denied.
cash.
He just never completed the application.
I totally understand, but on the basis of the pleading, the standing was satisfied in the sense of being able to say, I know. He actually has an affidavit supporting that, as well as evidence in terms of the exchange rates. He was actually providing the convenience stores, so he was providing exchange services. That was sufficient to make the determination to establish in terms of the court record that he was not going to get out of this regulation, and that the regulation was applying directly to him.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Eric Aaron for the respondents in this case, the New York State Department of Financial Services. As Your Honors have noted, there are a number of threshold grounds for dismissal in this case in Supreme Court. Our argument is that Supreme Court was correct to dismiss this case for both standing and lack of finality. All of the threshold grounds for dismissal...
Was there some information given to the petitioner that they would be denied if they applied?
No, there was not. The only communication from the Department of Financial Services to the petitioner said, essentially, we have no idea whether you're covered by the regulation because you have submitted an incomplete application. And so that was all he had been communicated to from the department.
So if he falls under one of the exemptions, can he state on the application, I don't have to fill out the application, or something to that I don't have to fill out the application, or this doesn't apply to me because I fall under exemption 1, 2, or 3?
He could have contacted the agency through any number of ways. I don't happen to know if there's a blank on the application that says that, because if a person's exempt from the regulation, then they wouldn't have to fill out an application at all.
Well, because his argument seems to be that he doesn't fall under the rubric, and therefore he didn't have to apply. So that was my question.
So I guess I would say in response to that, that it's not clear from his application, which included no information about his business, and his pleadings, which are entirely conclusory about what the nature of his business is, whether he was covered by the regulation at all, and if he wasn't, then clearly he
But there
doesn't.
was nothing on the application that says, I don't fall under the rubric, so I shouldn't have to apply.
That's right. And just one.
If you want to challenge the regulation on its face, do you have to get a disposition from the licensing authority?
I think in some circumstances, the answer would be no. There may be some situations where it is so clear. For example, there's a regulation about food carts, and a person has a food cart. It's obvious. Here, this is a new and evolving area of law. There are exceptions to the regulation. The agency, these are relatively new regulations, and so they haven't issued authoritative guidance or anything like that.
So I'm thinking, so suppose he finished the application and you granted him the license, would he still be able to come in and challenge the regulation?
He might have some argument that the burdens as applied to his unique situation were arbitrary and capricious or something of that nature, but that isn't what happened here.
That isn't what happened.
The last thing I'd like to note is that there was a point in the state's brief at page 30 that pointed out that at the moment this case was initiated, the petitioner was able to operate under the transitional provision of the regulation, even assuming he was covered by the regulation. He filed the case on October 16th, 2015, while his application was pending. There's a provision that was in the regulation at 200.21 that would have allowed him to operate essentially until his license was denied. At page, I think it's 239 or 139 of the record, there's an affidavit from the agency that makes clear that there are a number of companies actually doing that, operating years after the regulation came out. So there is no indication that the promulgation of this regulation in June of 2015 caused...
He didn't have to stop his business.
That's exactly right.
And how long would that have been in effect until the appeal process was completed?
Until the text of 200.21 says until the application was denied, and we know that as of the date that the agency affidavit was submitted, which was in, I think, May or June of 2017, 2 years after the regulation was promulgated, multiple companies were still operating under that provision.
Thank you.
There are no further questions. Thank you.
I think the key issue here is that the respondents has conceded that the regulation did not provide for a process to essentially get some form of pre-approval, because his challenge was essentially to address the power grab of the Department of Financial Services trying to regulate cryptocurrencies. At the time, by the way, things are very unstable. All of these jurisdictions are trying to understand whether or not this is even falling under financial regulations or not. So in
What do you make of his argument that your client could have continued to conduct his business under the transitional provision in the regulation while the application was pending, and therefore you don't have an injury in fact?
So in terms of the fact under police benevolent, which I understand is a third department case, threat of future harm is sufficient to qualify for standing. The whole notion of a startup that is subject to these quick adoptions of regulations is that the injury in fact issue is acquired at the time you make all of these efforts, essentially the investments. I mean, he's building the computer platforms.
But isn't that injury self-inflicted? I mean, you either fill out the application or you don't, or you continue your business.
Or you wait to before you enter into these contracts to get your license.
So when the adoption takes place and when he challenges the regulation, there is no signal from Department of Financial Services as to whether or not they're going to be tolerant with the waiting or the transition period. There are provisions under the financial and services law that essentially provide for the police powers of the financial services law of DFS, which he was subject to, which essentially convinced him to challenge it and then stop the business.
Thank you
Thanks very
both.
much.